National Report Court back in session. Today's case, Nike suing New Balance and Skechers, accusing them of wrongfully using its patented Flyknit technology. Nike saying this, that the special type of fiber the company developed that's used on the upper part of the shoe, and you see it on your screen. We're taking up the case here with attorney Mihek Cook, Andrew Lieb as well, an attorney and legal political analyst. So for the purposes of the segment, Mihek, if you don't mind representing Nike, Andrew, if you could represent New Balance and Skechers. So let's get it going here. We'll open up the court with this. Again, looking through the lawsuit, it states this, listing pages of alleged infringements from both Skechers and New Balance. And you're seeing some of the examples on the screen. Mihek, how strong of a case is there here for Nike?
Nike looks like they have a pretty strong case. They're truly, everybody knows, the big dog in athletic footwear and apparel. And it's no secret that competitors are going to toe the line when it comes to replicating technology. Nike clearly has an upper sole patented technology called the Flyknit. And if you look closely, just as a bystander, you don't even have to be an expert, you can actually see the way that the knitting is very similar to what Nike has. And by the way, Nike has litigated and settled successfully with brands like Adidas. What Nike really has to do is prove that there's physical evidence of their competing invention, which again, not even being an expert, you can see that there is clearly a similarity here, and the other brands are using Nike's patented technology. I have a hard time believing that Nike's going to bring a frivolous lawsuit. I think that not only looking at the material, but then bringing in an expert to actually deconstruct the shoe, Nike's going to prevail. I just think at what point do the other defendants decide that they just want to settle out of court, because this can get very expensive in terms of litigation.
Well, let's ask him himself. Andrew, again, representing that other side, if we still have you. Andrew, for its part, New Balance saying in a statement, quote, Nike does not own the exclusive right to design and produce footwear by traditional manufacturing methods that have been used in the industry for decades. Can you expand upon this case and, again, this argument?
It's a really simple case, and I'm shocked that my colleague brought up the Adidas settlement. Like, if you read the Federal Circuit decision here where Nike got destroyed on their patents, they were found that it was unpatentable. They got messed up by Adidas before that settlement because it's obvious. It's obvious. That's what the Federal Circuit said, because all their patent is removing stitches. That's not a patent. That's nonsense. So I would say this is frivolous. They're not the shoe gods or shoe lords or whatever. They're shoe dogs. That's what they're, dogs. That's what Nike is, dogs, because they're bringing a case that is complete nonsense. The Federal Circuit had 3 appeals. Appellate court ripped them apart after the trademark office said you don't got patents. Removing stitches is not patentable. And by the way, this is about saving material. And do you want us to use more material and more pollution? It's just ridiculous. The whole thing is nonsense. That's all I got for you.
Well, Mihek, can you respond to that? Is it nonsense? And then again, it wasn't just Adidas, it was Puma. How does that play? These previous settlements with Nike, how does that play into this?
Well, I think we have, as representative of Nike, you have patents that are clear on this Flyknit technology, and part of it is stitching, part of it is upper sole manufacturing. So it's not a mere stitch here or there. As my colleague probably knows, when you apply for a patent, it's extremely detailed process. You go through 6 months to a year of experts looking to ensure that a patent is necessary before you're even successful and prevail. Nike has tens of patents on this particular design that I have looked at. And if you want to get to the bottom of this, other brands have continued to rip off Nike's patent. This is not going to be a case that goes away easily. And I think, again, you just have to look at the evidence here, compare what these other competitors are doing with what Nike's patented technology is. If there wasn't a patent, then yes, this could be a frivolous lawsuit, but a patent holds a lot of weight in court. So again, I think this case will be settled outside of court. I think it would be a waste of money for the competitors to go after Nike and continue to drill down on the fact that they created a shoe that is very strikingly similar, not only in appearance, but also in comfort.
Andrew, before we go to the judge and jury here, for the purposes of the segment, I'll give you final word.
I just think you don't need to go to facts. You don't need to go to experts. You need to go to case law, Federal Circuit, Court of Appeals. Like they already ruled, they struck them all down. Nike has one limited patent, and that's when the one after Adidas. You haven't seen Skechers and New Balance could do. The patent holder has the burden to show that we're infringing. They can't show it because it's just removing stitches, and it's already binding case law on this issue. They lost multiple times at the patent office, and it was affirmed. That means upheld by the federal appellate court. That's the end of the day.
All right. And we had a little bit of a technical glitch there. Someone objected, clearly. I want to bring in Brianna Lyman if I can. So with the Daily Caller here. To play judge and jury again for this edition. You've heard both sides. Strong cases here. Where do you fall?
I got to go with Nike on this one. They spent, more than 10 years trying to develop this technology. They went through, more than 200 different prototypes. And in 2016, NYU actually said that their new technology was a breakthrough. So they worked really hard on this. If other people are trying to steal it as they allege, then good for them for going after them.
All right. Nike coming up. Mihek, thank you so much. Andrew, thank you for your time as well. With that, National Report Court is adjourned. Emma typically has the gavel. I don't have the props, so we're just going to have to go with that. Thank you both. Meanwhile, this anti-Semitism spreading across